Thank you, Mr. Chairman, and thank you all for coming before us. I represent Tennessee, and Tennesseans talk regularly about the importance of a fair judiciary, something that is equal treatment under the law. So having these hearings is important to us. Mr. Ruiz, I want to start with you. And very similar to what Senator Blumenthal was asking each of you, most of your background is in civil proceedings, and you have very limited experience in criminal proceedings, and you have not written significant opinions on federal or state constitutional issues in your role as a magistrate judge, even though you say you've learned quite a bit from that position. The majority of your writings and your decisions are unpublished. So could you tell us what in your judicial experience would give you the qualifications to sit as a district judge? And I'll give you about 30 seconds on that one.
Thank you for the question, Senator. During the past 5 years sitting as a magistrate judge, I had the opportunity to preside over extensive number of civil and criminal cases. During that time, as a magistrate judge, I'm responsible for approving and reviewing search warrants, pen traps, traces, criminal complaints, and other matters in the criminal world.
So you feel that the limited criminal and the civil work that you've had is a qualifier?
Thank you for the question, Senator. Not only the experience that I've had presiding over criminal cases and criminal hearings as a magistrate judge, I've also had the opportunity to prosecute a criminal case when I was in the United States Attorney's Office.
All right, let me end it with that because I want to go to Mr. Chun and talk with you about the amicus brief that the King County Bar Association submitted for Grutter versus Bollinger. The brief argued that promoting diversity in the legal profession is a compelling governmental interest and that this compelling interest requires race-sensitive admissions. So I want to know if you still hold that view. And do you believe discrimination on the basis of race is permissible in college admissions?
Thank you for the question, Senator. I believe that brief was written almost 20 years ago, and I was on a team of lawyers that put that brief together. When I played that role in putting that brief together, I was serving in the role of an advocate, and our client was the King County Bar Association, and so I was trying to advance their position as best as I could.
Do you hold that view? And I would, if you want to submit this in writing, that's fine with me. But I would like to know if you hold that view, that a compelling interest requires race-sensitive admissions, and if that would apply to college admissions, and in what circumstances would you apply that criteria? And is it okay to discriminate on the basis of race in hiring? So we will send this to you so that you can give us a written follow-up, because I think it's important. If you were to be confirmed as a U.S. District Judge, you would take part in appointing the magistrate judges, and we would want to know if you would be using race as a basis for that criteria, if you would use it for law clerks. So let's get that to you in writing.
Okay, thank you.
Let's see, Mr. Fleming, do you believe that a 14-year-old can consent to sex with an adult?
Thank you for the question, Senator. I know that different states, like the state of Ohio, have an age of consent. And in the state of Ohio, the age of consent is 16. Okay. So I would be guided by the law and the precedent.
Specifically about U.S. versus Evans. Okay. You filed a sentencing memorandum in U.S. versus Evans for a defendant who was found guilty of cocaine possession and distribution. What you did was to move forward with that had convictions. One of the convictions was corruption of a minor, which involved the statutory rape of a 14-year-old girl that resulted in the birth of the defendant's son. You argued that this rape should not be used as a predicate for career offender status because the victim had a son by the defendant and maintained a romantic and parental relationship with him. So I understand that as an attorney, you need to zealously represent your client, but I need to clarify your views for me. Do you believe that if a rapist impregnates his victim, it is no longer a crime of violence?
Senator, at that time, I was not espousing my particular belief. At that time, what I was asserting to the judge was that based on the state of the law and the state of the sentencing guidelines, that the court should consider the circumstances surrounding that conviction.
My time has expired,
Okay.
but I hope you understand that when an adult rapes a child and that child stays with her abuser, that is not a relationship. That is abuse, and that is called grooming. Thank you, Madam Chairman. I yield.
Thank you, Senator Blackburn. Senator Cruz.
Thank you, Mr. Chairman. Welcome to each of the nominees. Congratulations.